Hi, I'm Karl K. Gallagher, here to talk about publishing contracts you should not sign. Now, let me lay out a few ground rules on this. I'm not a lawyer. I'm here from the writer's point of view. Also, in my day job, working for a federal defense contractor, I once caught a year's worth of 7 p.m. meetings because of a single badly worded sentence in a contract. And that's the sort of thing that makes you sensitive to how bad your contract can be. And I want to share some of what I've learned about publishing contracts with you. Now, this is not legal advice. I'm not allowed to give legal advice, but it's information you may find useful. The contracts I'm showing here are not mine. There's one I refer to as the evil contract, and I do not own it, and I am showing excerpts for purpose of criticism under fair use. The good contract excerpts are from the SIFWA Model Magazine contract, which you may want to take a look at online. I apologize in advance for this presentation. I hate throwing walls of text at people, but these are contracts, and a contract is a wall of text. So that's really what we have to do. So let's look at first at the different clauses in a contract. The most important one for publishing is the rights clause. You own the copyright in a story you've written, and you share rights in that copyright with someone who's publishing for some appropriate compensation. So the question is, when you're publishing, how many of the rights to your copyright are you sharing? Well, if you look at the highlighted yellow text in the evil contract here, it's asking for print, electronic, indefinite, worldwide, in perpetuity, and they want to translate, perform, display, distribute, and exploit, through sub-licensees means that they can hire somebody else to do this stuff. This is a whole pile of rights they're asking for. Now, in a good contract, they are asking for a specific right. In this case, they want to publish online, so they want first world electronic rights in English. That's a very specific thing for which you get a specific compensation. In the evil contract, they're asking for not just English rights, but all sorts of stuff. They want translation. So German, Swahili, they want the right to translate this, and they want it in perpetuity, which means that you can never set up an exclusive contract for that with anybody else. And then you get to the exploit term here, and exploit is everything. I mean, you may think of Star Wars and merchandising rights. You're giving, merchandising rights to the short story. Is that a big deal for a short story? Maybe, maybe not. But you're also giving them the permission to write a sequel to the book, to the short story. You're giving them permission to turn that short story into a novel. They can hire somebody else to do that. Exploit is totally open-ended. And just for reference, the original offer that came with this contract was for $27. So it was $27 for everything connected with that short story. I didn't sign it. I know other authors who have signed this contract. Now, even worse than that is, if you look at the beginning of it here, it's by submitting writer grants to the publisher, and then at the end of the clause here, if publisher publishes the work, it shall pay, which means that you're giving up all those rights, even if they don't pay you the $27. That's the kind of contract that, in my opinion, you should not sign. You should be signing contracts that have specific limited grants of rights. Now let's look at some of the other dangers here. The warranty clause. That's pretty standard in a contract, and usually what they want is for you to sign that you did not plagiarize this, that you are not taking this from some real life incident from somebody who would not approve of you using it as a story, that sort of thing. So in the good contract, you have a thing that, to the best of the author's knowledge, the work doesn't infringe against any copyright or personal right. Now, in the evil contract, that's written much more broadly, to constitute a libel, slander, or any unfair competition, whether to your knowledge or not, against any third party. So if somebody you've never heard of, takes offense at your story, you're in violation of that contract. That's something that makes you vulnerable to lawsuits. Now, another piece of lawsuit insurance in the evil contract is the uniqueness clause, which is unique to the evil contract. The good contract does not have this clause. And what this all pretty much boils down to is, just because we published a story or made a movie that's really like your story doesn't give you any grounds for suing us for ripping you off, because somebody else could have come up with that completely independently. And these folks are from out of Los Angeles. Hollywood has lots of problems with people suing about stories. So kind of inherent in this clause is that frivolous lawsuits are a thing, and they want to defend themselves against it. Well, then the next thing about dealing with lawsuits is the indemnity clause, which means that if the publisher gets sued, you are required to compensate them for any losses that they take or that any member of the company may take. And so this is written very broadly, all claims, demands, losses, costs, expenses, obligations. So you have to pay for not just a court judgment, but legal fees, any out-of-court settlement, that anybody has to do with this has to pay. Now, in the good contract, there's a similar clause, but it's much more limited. Because one, you're only liable for an intentional breach of the warranties. The publisher is expected to have insurance policies, and the insurance policy will cover the author as well as the company. And very important, legal representation and the decision to settle will be made together. Under the evil contract, the publisher could say, hey, we've been sued, this is totally frivolous, but we'll give them $250,000 to go away. Under the good contract, you have the right to consult with them, to be part of that, to get your own lawyer, to be part of the decision in advance, to see if this would be covered by insurance. Under the evil contract, you could get a letter that says, hey, we settled out of court, pay this guy $250,000. And it's already been settled. There's already a court order in place, and you're totally unprepared. And there's this guy coming after your house because you do him. Now, if you're a penniless author, and traditionally a lot of authors are, big deal. You can give them your pen, you can declare bankruptcy. But for authors who are doing this as a side gig and have a family they support, losing your house is a pretty dramatic disaster, and you do not want to sign a contract where you could wind up losing your house as a result of publishing a short story. And yes, it's unlikely, but unfortunately, the legal system is such that anybody can sue for anything, and you have to deal with it later. Now, the next clause we'll take a look at is the assignment clause. And this is talking about, can your side of the contract be transferred to somebody else? And that's a very common thing with corporate mergers. Corporations will, sell off parts of their business, and sometimes there will be mergers solely to acquire a publisher's back catalog of books that they have established contracts on. Now, under the evil contract, the agreement can't be assigned to anyone else without the prior written consent of the company. And for me, that's a little amusing because, the only thing where I'd wind up assigning it to someone else is if I die and I have a literary trust set up to handle my all my works if I die. And so you read this contract literally, I'm not allowed to die without this publisher's permission. Now, on the flip side, it's explicit that the publisher can transfer all of its rights and retain everything. So they can sell my contract to somebody else who wants to publish it, or exploit some of the other rights that existed earlier under the rights clause. Now, under the good contract, it's restricted that the publisher may not transfer the contract without the written permission of the author. And that's great, and that can save you from stuff like Alan Dean Foster having a fight with Disney because his contract was transferred to Disney, and Disney said, well, we're keeping the rights to publish, but we're not buying the right to keep paying royalties to Alan. That's hopefully going to work out, but if a clause like this could have prevented that happening in the first place, because they would have needed to get Alan his permission to transfer the contract in the first place. Now, that's not going to save you from everything. If a company goes bankrupt, the contract is an asset of the company, and the bankruptcy judge may not feel himself limited by this clause. The remedies clause, this is if another clause of the contract is broken, what can you do about it? And in the evil contract, it's very strictly limited that, okay, if we're sued, we'll pay monetary damages, but the contract is not broken. We don't have to take the story down from our website. We don't have to pulp copies of the magazine that were already published. And, oh yeah, we're not going to pay anything other than, strict damages, so there can be no punitive damages under this contract. Which I find a bit interesting because, does this contract actually have the power to tell a judge, no, you can't rescind this contract, or tell a jury, no, you can't issue punitive damages? So that's an interesting legal question, and I can talk to some of this stuff, but that's one you'd really want to ask a lawyer about. But frankly, if you're worried about that end of it, the simplest way of avoiding this problem is to just not sign the contract. Now, on the good contract, there's some restrictions on the remedies clause, which is that it wants to be tried only by a court and not a jury. And that's simply trying to minimize the amount of legal fees that are going to be involved, because a judge-only trial would be a lot quicker and simpler than a jury trial. Some of the other clauses that are in there. In the evil contract, there's this fascinating little clause that the agreement isn't considered to have been written by either the publisher or the author. So the author can't go to court and say, hey, I didn't understand this, they wrote it, I'm being screwed because I didn't understand the contract that they wrote. And it specifically has a thing here, author hereby waives any rule to the contrary, including California Civil Code section 1654. I kind of look at that, and this is another thing where I'd be curious to ask a lawyer knowledgeable in California law, is this actually legal? But I think for our purposes today, the real takeaway is, you know what? if these people want to have that kind of level of protection to enable them to keep you from complaining about being screwed over, maybe they're planning on screwing you over and you shouldn't sign the contract. Another clause here is the agreement may be executed in counterparts, which is pretty much that you each get sent a copy of it and you sign your copies separately and then send those in. In the good contract, it's specific that there has to be a copy with everybody's signature on it. And this is only an issue. I mean, I've actually done counterparts contracts, but that was with people I trusted. And if you're all signing the same physical copy, that means you all have the exact same text in front of you, as opposed to having different versions being signed by different people. And after some of the other clauses here, it makes me kind of paranoid about what exactly is in this contract. So some of the other clauses, stuff that's pretty standard. There will be a jurisdiction clause that says which state's law applies. A severability clause that if a court finds one clause invalid, the rest of the contract is still considered intact. It will say that the contract supersedes previous communications, which is to say if you had a phone call with the editor who promises you something, what's actually in the contract is what's final, not the verbal promise you had. And that the contract can only be amended by mutually signed written communications. So if you're going to revise this, it's going to be essentially a new contract signed by both parties. Now, some contracts will be done on a handshake deal. The text I have here is an email that I sold a story on, and it's pretty much offering me cash for the purchase of it, telling me he'll PayPal it, wanting the global print and digital publication rights, that he wants a 1 calendar year period of exclusivity, and that they're going to have a non-exclusive sale of it in the anthology or magazine that they were selling this in. And, you know, a standard exception for that is if there's a best of the year collection, you know, magazines will allow one of their stories to feature in that and not consider that a violation of the exclusivity clause. Now, the thing with, you know, I refer to this as a handshake contract despite doing it over email. You know, this was an editor I'd had a personal relationship with. This is a semi-pro market, so a low word rate, not a whole lot of money being done. The publisher was doing the magazine as a side gig, so there was no deep pockets to sue on either side. This isn't something where he was going to come after my house to protect his corporate assets. We were both in an equivalent financial situation. And even with that, as this publisher stayed in the business and put out more issues and it grew, he wound up replacing his handshake agreements with a more detailed contract as things got more complicated. Now, I want to dig into a traditional publishing contract and get into a bit more detail here. You may have heard of the movie Pride and Prejudice and Zombies, or the novel it was based on. That was written by Seth Grahame-Smith. And kind of keying off the success of that, he had a contract with Hachette Publishing for another 2 novels, and they offered him $4 million. And I will admit, for $4 million, I'm going to be very tempted to sign the contract and get that money. Well, later on, Hatchett wound up suing Seth Grahame-Smith for a return of part of that $4 million advance. And because there was a lawsuit, they had to enter the complete text of the contract into evidence in the suit. So that has been made public. And that's something that's pretty rare. Generally, contracts are held tightly confidential. Part of why I'm giving this talk, rather than someone with more experience in contracts, is that people with more experience than me in contracts are often in a position where they have non-disclosures that keep them from discussing it in great detail. So let's dig into a few of the clauses of that contract and consider, should he have signed it? All right, so first off, let's look at the $4 million. When he signed the contract, he did not immediately get a $4 million check. They broke that into 8 pieces. And for each book, the first piece was given to him on signing the contract. And then for each book, there would be another piece on delivering the manuscript, the publication of the hardcover edition, and then the publication of the paperback edition. And so they pretty much followed that schedule up to step 5. He turned in the first book. It was published in hardcover and paperback, and he'd received $2.5 million at that point. And then it was time to turn in the manuscript for book 2, and he didn't. He eventually turned it in 3 years late, and it was like Pride and Prejudice and Zombies, a out of copyright famous novel into which he had inserted a whole bunch of fantastic elements. And apparently the folks at Hatchett decided that he didn't do it as well this time, or that fad was over, and they rejected it. And Seth Grahame-Smith kind of shrugged his shoulders and decided to go on with his life. And Hatchett was pissed and decided to sue him for the initial payment on contract signing for book 2. So that was $500,000 that they wanted back. Now, digging into some of the other issues in here, one of the contract clauses that I think maybe Seth should have had qualms about in this contract was that he had a previous contract with Hatchett for 2 novels and a separate contract for audiobook editions. And so he had advances from them, and the books were paying royalties. However, for those not familiar with how traditional publishing works, when you get an advance, that's not just a flat payment, that is effectively a loan against the royalties that are going to be earned from your book. So for each of those books, there was an advance, and as the royalties from the sales of those books came in, they would pay off the advance. And once all the advances were paid off, then Seth would start receiving new royalty checks. And that's referred to as earning out, and is a happy day for authors because it means they're going to start receiving regular checks for all their books that have earned out. So what Hatchett did was they included a clause in this contract to jointly account the 2 books under this contract with the previous 2 novels and their audiobook editions, which means that any royalties Seth received for the earlier books were going to pay off the advance under this contract. And thus, even if they'd earned out, he would not receive royalties from them. They would keep going to the publisher. The marketing activity clause had a line in it that, as I read through, I found rather scary. The whole point of going with a big traditional publisher instead of being an indie publisher is that you have this big outfit with all the connections and tools to do marketing and contact the book reviewers, place advertising in the right places, pass the word to the right people to talk up your book, and generally help you get a whole lot more sales than an author just operating on their own would be able to get. But the clause here says the publisher shall have the sole discretion to determine what, if any, advertising or promotional services may be performed. And that means they may not promote this book at all. They will look at how things are once the book is already out and decide if they want to put any more effort in. Now, they are gracious enough to put in this same clause that the author may perform such advertising and promotional services as they think will benefit. But, if you're going to be doing all of the work to promote your books, what's the point of having a deal with the big publishing company, other than the, $1 million up front, which I grant may have been a big factor for Seth. Now, another clause I found rather scary is the agency clause. And, Seth already came to this deal with an agent lined up, Claudia Ballard from the big name William Morris Agency. And this clause in the contract is defining the agent's relationship with the author for the purpose of these books. And in particular, the contract says proprietor, referring to the author here, irrevocably appoints the agent. So it's saying that as far as these two books are concerned, Seth can't fire his agent. And there is also the specific thing, clause 3 here, that to receive an agent's name, all monies due. So once Seth does receive money for these books, assuming the advance earns out and he's getting stuff, getting royalty payments, the royalty payments would go to the agent, who would take out their 15% and then send the rest on to Seth. Now, some paranoid folks might wonder, wow, is there a chance that the agent could take out more than 15% or do some other embezzlement? And yeah, that happens. I'm forgetting the name of the agency offhand, but the agent for the guy who wrote American Psycho, that agency embezzled several $1 million from their clients, keeping payments that had come from publishers and not passing them on to the authors. So that's something someone may want to be a bit worried about. Now you're wondering, why is this even in the contract between the author and the publisher? Well, if you look down at paragraph 25B, you see that these provisions are specifically included for the benefit of the agent. So while negotiating this contract with Hachette for the author, the agent put in this clause for their own benefit. And here we have in 25B, if there's any inconsistency between the terms of this paragraph 25 and any other agency agreement between proprietor and agent applicable to the work, the terms of this paragraph 25 shall prevail. So if Seth Grahame-Smith had been, professional enough to set up a specific contractual agreement between himself and his agent to restrict what his relationship with the agent was, say what terms he could fire the agent, how money is supposed to handle, and so forth, that contract is overruled by the agency clause of this contract that he's signing. And that's a pretty specific conflict of interest. And I would certainly not sign a contract that had a clause like that. And then something here that is not as significant as some of the other stuff we had, but I found it almost amusing in the way that it drove home the relationship. You know, book tours are a specific type of promotion, you know, so standard that it's discussed in the contract. And one of the things it's saying, okay, Seth, if you're flying to every big city in the country, spending lots of times in the air, you know, we will buy you business class tickets. However, if we have your editor or someone else from the publishing company on the plane, you can travel first class with them because the editors always travel first class. And that's just something that for me drove home what the level of relationship is between the you know, the publishing outfit and the author here. So my strong recommendation from all of this is to read and understand your contracts. The house you save may be your own. Now, I would also urge you to review some of the links here and do some reading on that and possibly keep them as references. SIFWA has a contracts committee that has put out magazine contracts, anthology contracts, and some other standard reference contracts. And those are online at their site, and they're worth reviewing. And if any of you find yourselves on the publishing side of this, that's not a bad place to start for putting together contracts with your authors. Someone that I found to be a great source of information on dealing with contracts, agents, and similar publishing business issues is Chris Rush. If you go to her chriswrites.com website, she has regular blog posts. And if you go to the contracts and deal breakers field under that, you know, that will define, you know, that collects a whole bunch of posts about things that you should watch for with contracts. And really, that was some of the things that got me looking for these sort of things that I've been talking about in this talk. For the Seth Graham Smith contract that I was showing you clauses from, here's the link to that. I checked it a few days ago, and it was still online. So go ahead and do that. There's some other legal paperwork in it, but pages 9 through 21 are the whole contract. And yes, it is, you know, 12 pages of the kind of font that I was showing you on this slide. So it's a hell of a lot of reading, but it is some fascinating stuff that is worth thinking about in advance, so that you're not having to think about it while somebody's waving some money under your nose. And then the last one, which I didn't really have time to get into much here, is the question of how to option motion picture rights for your book. There's a book, The Indie Producer's Guide to Optioning Motion Picture Rights to Books, which is aimed at a Hollywood producer who wants to get somebody's book. And so pretty much as a writer, you would want to go through this book and reverse all of the advice, but I suspect you would find it fascinating reading. And just as a parting comment, we'll have a few parting words from the folks at Penny Arcade. Few people have signed as many bad contracts as we have and survived, so let us help you out. Is someone trying to make you sign something? Then assume this person has been sent by the devil to destroy you. Don't be nice. Being nice just makes you a juice box for vampires. Their livelihood depends on them stealing the best years of your life and then changing you out when your mind gets away. And claiming ignorance after the fact won't get you out of this shit. Trust me, I'm super ignorant, and it hasn't helped at all. So thank you very much for your attention, and I'd be happy to take any questions folks have.